Okay, so I have Noha Mendel Sohan Aviv online with me. She is executive director of Canadian Civil Liberties Association. So, as I was sharing with our listeners in the beginning, that there is a landmark judgment by our federal court, Justice Richard Mosley, that the Emergency Act, which was imposed by our present liberal government, was unreasonable. So at that time, we all know that thousands of people from all over the country, they had a strong protest against various policies of the government during COVID time. Freedom Convoy was the name of this protest. So this case was going on, hearing was going on at the federal this court for a long time. Now, the judgment itself is a very strong and derogatory against the present government. So, what does it mean? We are here, we have Noah with us, and she will tell us in a better way. Canadian Civil Liberties Association and many other groups, they had filed petitions. Noah, welcome to Radio Parvasi and good morning.
Good morning.
First of all, tell us of the petition you guys filed in the federal court.
Yes, so we challenged the government's declaration of emergency and their use of the Emergencies Law, the Emergencies Act, because it is a massive power that the government gives to itself and should only be used in really sort of extreme circumstances of a threat to Canada's national security, as opposed to what was happening in Ottawa, which was a very serious issue in one location that needed to be dealt with by police, was dealt with by police, and did not justify bringing in this emergency law that gives government the kind of power that it does to pass new laws without the normal democratic checks and balances that we need in a free and democratic country.
Okay, no, but we all know that this was the first ever time that this Emergency Act was implemented or imposed. We have never been seen this kind of action taken by any government, any previous government.
That's correct. And so we had, before the Emergencies Act, there was the War Measures Act to deal with, other emergency situations, and the government used that improperly. And our organization, the Canadian Civil Liberties Association, stood up to the government then in 1970 when they violated people's rights and freedoms right across the country using the older emergencies law. And then we fought for a new emergencies law and said it has to have a stricter standard, a higher threshold before government can use it. And in the federal court decision yesterday, the judge agreed with us. The court agreed with us and said, yes, the government did not have, it was not reasonable for the government to give itself emergency powers to deal with this situation. Canada has dealt with difficult situations before, difficult policing situations, situations of terror, situations of ice storms, without using federal emergency powers.
Okay, no, but this has given bad name to Canada as well because Canada claimed itself as democratic champion. We claim that, and we are proud of our democratic values which we uphold. But many countries, they started saying that you guys are imposing emergency act on your citizens and you claim that you are champion of democratic values.
Yeah, it's, the government claims that they did what they thought was best at the time. And what the court said yesterday, the federal court said, look, there may have been a difficult situation in Ottawa, but you cannot use emergency powers because it is there or because it seems more convenient or because it seems an easier way to address the problem. And ultimately, they didn't even use most of the powers under the Act to actually stop the protest. But the court said yesterday you can only use these powers in emergency situations, and that is what we have been saying from the very beginning, since they declared the emergency powers they're necessary in an emergency, but they are dangerous to democracy, and they cannot be used unless there are exceptional circumstances that did not exist, because the situation in Ottawa could have been was managed using regular policing.
Okay, no, but at the same time, we saw that there were thousands of trucks entering Ottawa, nuisance for the citizens, residents over there. There was noise, there was pollution, there was, allegation of harassment. So,
Yes.
and on the other hand side, there was a clogging at the border crossing. How you justify that?
So I mean, we weren't there to justify the protests. We weren't there to justify the blockades. We actually believed that it was necessary to dismantle the blockades. The question was not whether to dismantle them. Everybody agreed that what the residents of Ottawa had gone through was very difficult, and the harassment, the intimidation, the assaults on marginalized communities, racialized communities in Ottawa was not justified, and that was done by some of the protesters, certain protesters. That needed to stop. We had no disagreement about that. The question was how. Could they do it using policing, or did they, in fact, meet the high threshold required in order to bring in federal national emergency powers? We said no, and the court said no. And not only did they use that law when they should not have, when it was unreasonable to do so, according to the federal court's decision, but they then passed additional laws that don't have the usual democratic checks and balances, and those laws violated fundamental charter rights. They shut down protests, not just at border crossings, not just in relation to vaccines. They shut down all protest across the country. And we know that protest is necessary for everybody to stand up for their own rights, to stand up for other people's rights on all sorts of issues. They also used those additional laws that were created without the regular democratic checks and balances to freeze people's bank accounts, to turn financial information over and violate people's privacy. So there were very serious concerns about what they did. The blockades that happened at other border crossings, as you probably remember, were actually taken apart and dealt with either by provincial police services, including the Ontario provincial, by provincial services, by the OPS. So all of that had been dealt with around the time that the emergency law was used and the emergency was declared.
Okay. Thank you so much, Noah, for sharing all this information with us. We know that even Prime Minister was taken to some undisclosed location. The situation was, explained as so dire at that time, dangerous at that time. But as you're saying that the federal government and the other law enforcement agencies, they were not able to handle the situation in a way, and this was the least requirement to implement this law. At least that was not that kind of emergency which the government used at that time, used its power at that time. And now, of course, it's a big embarrassment for the federal government. They are saying that they are not accepting it and they are going for appeal.
They are, and we are going to respond, and we're going to continue to fight it, because we know that emergency powers are dangerous for all of us, for all of our rights and freedoms. And this government and every future government now knows that we are all paying attention,
Okay.
that we will fight it, that we will stand up for our rights, and that's why we're there.
Okay. Any compensation has been announced by the judge? Other than this?
Sorry, I can't quite hear what you said.
My question is, any compensation, financial compensation or any other kind of compensation given by the judge to all those people who were affected?
So I'm here on behalf of the CCLA. We did not seek any kind of compensation or even, to be given money for our financial costs. We were there arguing in the public interest for the public. We didn't ask for any kind of legal costs, and the judge didn't give it to us, and that's absolutely fine. We rely on the support of people in Canada who give to us as an independent watchdog organization to stand up for everybody's rights. And people have been incredibly generous and helpful in supporting us. Of course, we need a lot more help because there's a lot of work that we need to do.
Okay, thank you, Noah. And I'm sure any other, future government, they will think many a times before implementing this this kind of emergency act in future, because the kind of strong judgment given by the Supreme Court of our country. So this is the highest court which has given this decision yesterday. Noah, thank you so much. You want to share anything at the end?
No, I really appreciate the opportunity to speak with you and to share this very, very important decision with your listeners. It is a historic decision. It was the first time this law was used. There are emergency powers. We need to pay close attention to what our governments are doing in order to keep ourselves free and safe and equal to fight for justice. So I'm very glad that we get the chance to have this conversation. Thank you.
Thank you so much, Noah. People come from all over the world to Canada, keeping in mind that this is a country where everybody has equal opportunities, equal rights, and we are so proud of our Charter of Rights and Freedom. And we know that this country has given us so many these kind of rights, but this kind of action taken by this present government definitely was not required at that time, as far as our Supreme Court is concerned, and it has a very, very strong impact, keeping in mind for the future governments. Noah, thank you so much, and we will talk to you soon again.
Thank you very much.
Thanks a lot. ਤੁਸੀਂ ਜੁੜੇ ਹੋਏ ਹੋ ਰੇਡੀਓ ਪ੍ਰੋਗਰਾਮ ਪ੍ਰਵਾਸੀ ਦੇ ਨਾਲ। ਤੋ ਨੋਆ ਮੈਂਡਲ ਸ਼ੋਹਨ ਅਵੀਵ ਇਹਨਾਂ ਦਾ ਨਾਂ ਹੈ। ਇਹ ਐਗਜ਼ੀਕਿਊਟਿਵ ਡਾਇਰੈਕਟਰ ਨੇ ਕੈਨੇਡੀਅਨ ਸਿਵਲ ਲਿਬਰਟੀਜ਼ ਐਸੋਸੀਏਸ਼ਨ ਦੇ, ਜਿਨ੍ਹਾਂ ਨੇ ਅਸਲ ਦੇ ਵਿੱਚ ਜਿਹੜੇ ਲੀਡ ਕਰ ਰਹੇ ਸੀ ਇਸ ਪਟੀਸ਼ਨਸ ਨੂੰ ਜਿਹੜੀਆਂ ਪਾਈਆਂ ਗਈਆਂ ਸੀ ਐਮਰਜੈਂਸੀ ਐਕਟ ਲਾਗੂ ਕਰਨ ਦੇ ਖਿਲਾਫ। ਤੁਸੀਂ ਜੁੜੇ ਹੋਏ ਹੋ ਰੇਡੀਓ ਪ੍ਰੋਗਰਾਮ ਪ੍ਰਵਾਸੀ ਦੇ ਨਾਲ।